Hi class, good day. So first lecture we discussed Title 1, the crimes against the national security and the law of nations. So now we will be discussing Title 2 of the revised Penal Code, crimes against the fundamental laws of the state. So what do we refer to when we say fundamental laws of the state? So we refer to the Constitution. So the fundamental law of the state, the Constitution, includes there the Article 3 Bill of Rights. So you have the Constitution provides for the rights of persons. So Bill of Rights serves as limitation to the power of the government mainly. So this crime is committed by the those who are in the government, the public officers who are in the government, um, and they commit it against persons. So if you're a private person or a person in general, you have set of rights, which is embodied in your Bill of Rights. So if a public officer or employee commits a violation of that Bill of Rights, then they can be prosecuted for such crimes under this title. Okay? So what are these crimes against the fundamental laws of the state? First is arbitrary detention. Second is delaying the delivery of detained persons to proper judicial authorities. Third, delaying release. Fourth, expulsion. Fifth, violation of domicile. Sixth, search warrants maliciously obtained and abused in the service of those legally obtained. Seventh, searching domicile without witnesses. Eight, prohibition, interruption, and dissolution of peaceful meetings. Nine, interruption of religious worship. And 10th, offending the religious feelings. So first crime under this title is Article 124, arbitrary detention. So what kind of rights are violated sa muni? Arbitrary detention. So before you answer that question, what is arbitrary detention? So arbitrary detention is committed when a public officer or employee detains a person without legal grounds. So makita nyo man na yung definition sa iya nga elements. So meaning kung anong ginamin nga wala legal grounds or absence of legal grounds, first no crime was committed by the detained, di ba? Kung wala man may na-commit ka crime ang detain nga man siya i- i-detain or ikulong. Second, there is no violation. There is no violent insanity of the detained person. So, third, the person detained has no ailment which requires compulsory confinement in a hospital. So, hindi man siya ill, hindi man siya insane, wala man siya commit na crime, so there is no legal ground for him to be detained. So if there is no legal ground for him to be detained and he is being detained by a person or a public officer or employee, then the crime of arbitrary detention is committed. So there are several forms of arbitrary detention. So what are these forms? First, atong 124 again, detaining a person without legal grounds under this article 124. And then second is having arrested the offended party for legal grounds but without warrant of arrest. And the public officer does not deliver the arrested person to the proper judicial authority within a period of, you will know later kung ano ning significance ng 12, 18, and 36 hours as the case may be. Or delaying the release by competent authority with the same period mentioned in number 2. So there are three forms na gina-assume sa arbitrary detention. Okay. So, Article 125, delay in the delivery of detained persons to the proper judicial authority. So, if you notice, this is the arbitrary detention form number 2. Diba? Kanina, sa previous slide. So, this is committed when a public officer or employee detains a person for may legal ground. But then again, he fails to deliver such person to proper judicial authorities within 12 hours for light penalties, 18 hours for correctional penalties, and 36 hours for afflictive or capital penalties. So, ano na siya dapat? So, for example, mga law enforcers na kamo, because in the near future, you will be law enforcers na. So, if you caught a person in flagrante delicto, or you caught a person in the act of committing a crime, then you should deliver them to proper judicial authorities within 12 hours if it is a light penalty kind of crime that was committed. I mean, if it is a crime punishable by light penalties. Okay? And B, 18 hours for correctional penalties, and C, 36 hours for afflictive or capital penalties. So it depends on the gravity of the crime that they committed. So if they committed such crime, then you have to deliver them to proper judicial authorities. What do we mean by proper judicial authorities? Okay, so keep your answers in mind, okay? So, proper judicial authorities, we will explain it sa aton nga quiz, okay? So, you have to research on what is meant by proper judicial authorities, okay? That's an assignment. Okay, delaying release. This is the third form of arbitrary detention, delaying release. So what are the acts punished? If you delay the performance of a judicial or executive order for the release of a prisoner, unduly delaying the service of the notice of such order to the said prisoner, and unduly delaying the proceedings upon any petition for the liberation of such person. So elements, dapat public officer or employee, there's a judicial or executive order for the release of the prisoner or detention prisoner, and that there is a proceeding upon petition for the liberation of such person. And then the offender without good reason, good reason, delays the service of the notice of such order to the prisoner, the performance of such judicial or executive order for the release of the prisoner, or the proceedings upon a petition for the release of such person. So, sa tatlo ni guys, Article 124, 125, and 126, what do you think is the right under the Bill of Rights that is violated by these three articles? I mean, these crimes. Okay, if a person commits any of these crimes, what is the right under the Bill of Rights that is violated? It is a okay. You answer it. Okay? I will pose a question and you should answer it. Okay? Sa group page, I will post a question under the group page, and then you answer what kind of violation it is. Okay, it's just simple exercise, no grade, but then again, it helps you if you make your mind work. Okay, if you exercise your brain, you'll learn better. Okay, next. Article 127. Fourth crime under this title is Article 127, expulsion. So, what is the crime of expulsion? Expulsion is expelling a person from the Philippines or compelling a person to change his residence. So, you'll notice, man, this is a violation of one of the rights under the Bill of Rights because a person has a liberty of abode and of changing the same. Okay, so you check what section in the Bill of Rights is violated by this crime or expulsion. This is committed by a public officer or employee who either expels a person from the Philippines or compels a person to change residence, and the offender is not authorized by law to do so. So what if, like for example, squatters? So pahalino ng squatters, tapos si Silo sa ibang nga lugar. Is it authorized by law? You think about it. Or for example, the persons who are under a hazard or is occupying a portion of land which is hazardous. Like for instance, they are occupying a seaside property or seaside land, and and facing an open sea, for instance, and there is a hazard na ano sila maguba ang ilang mga balay or mapatay sila due to storm surge, for instance, or tidal waves or tsunami or tsunami. Okay, never mind. Okay, so that is expulsion. So you think about it, if the reasons for the changing of the abode is authorized by law. If it is authorized by law, like for instance, there is a law that passed that hindi ka pwede maka-star sa mo ng property because it is a hazardous place, then you can be expelled from that property. You can be compelled to relocate, di ba? So if it is authorized by law, then it's not expulsion. But if the expulsion is not authorized by law, then it is a crime for a public officer or employee to demand a person to change residence without proper justification why she should not change residence. So there is a case in your module regarding that, and it's a very nice case because a mayor of the city, a city of mayor of a certain place, ginpalayas niya ang mga prostitutes. Here's the case. In the case of Villa Vicencio versus Lucban, a mayor of the city of Manila wanted to make the city free from prostitution. So, ginpalakat niya mga prostitutes. He ordered certain prostitutes to be transferred to Davao. So, wala siya nag-observe sa due process, and they have not been charged with any crime at all. So, it was held that the city mayor has committed a crime of expulsion. Diba? Nice case. Well, anyway, let's move on to Article 128, violation of domicile. So there are so many examples in your modules regarding this. You read it because it's just like this is the beauty of criminal law. It's just like reading a story, and then you identify what was committed or if there is any crime that was committed at all. So, you read the modules, please. Okay? Act Spanish for violation of domicile, entering any dwelling against the will of the owner thereof. Second, searching papers or other effects found therein without the previous consent of such owner. Third, refusing to leave the premises after having surreptitiously entered the said dwelling and after having been required to leave the same. So, lain-lain. First, kung nagsulod ka sa dwelling against the will of the owner. So, nang popular ni sinyo as trespassing, di ba na? But then again, you must remember that the violators of this crime or the offenders of this crime is or are a person who can be the offender of this crime or who can commit this crime is a public officer or employee. So this is like trespassing, but then again, because public officer or employee ang nag-commit, the name of the crime is violation of domicile. So I just said trespassing kay mas familiar sa inyo, but then again, for easy recall, gin-mention kong trespassing. We will discuss trespassing later on sa next crime, next titles, sa succeeding titles, I mean. So, also searching papers or other effects found therein without the previous consent of such owner or refusing, di ba? Number 2 is a violation of the right against unreasonable searches and seizure under your Bill of Rights. And refusing to leave the premises after having surreptitiously entered the same. Bali, surreptitiously, nagtatago-tago ka sa doon. And then, nakita ka sa owner, pinambalan ka nga maglakad, but then again, wala ka na lakad. So, that's it. Okay, common elements, public officer employee, not authorized by judicial order. Of course, if there is a search order or search warrant, I mean, or any judicial order for you to enter that specific place or dwelling, then you're not committing any crime because you're just following a judicial order. Then again, kung wala sang judicial order, then it is a crime. Okay. Article 129, another violation of unreasonable searches and seizure. Provision of your Bill of Rights. Search warrants maliciously obtained and abuse of service of those legally obtained. So, what is the act punished here? Nag-procure ka sang search warrant without just cause. So, nagpinabuang ka lang procure sang search warrant. An offender or a public officer or employee procures a search warrant without just cause. Or, another gina-punish, exceeding his authority or using unnecessary severity in executing a search warrant legally procured. So like for instance, kamo as police officers, as law enforcers, so dapat ang pag-execute nyo man sa search warrant must be reasonable, must be within the bounds of the law, dapat hindi man abusive. Because if not, you can be liable under this crime. Abuse in the service of those legally obtained nga search warrant. So may search warrant, kaya man tuod, you're allowed to enter the property or to search the house, for instance, or any room. But then again, you abused your power or you went beyond what is necessary to execute the search warrant, then you will be liable under this article. The offender is a public officer or employee, legally procured the search warrant, but exceeds his authority or uses unnecessary severity in executing the same. Okay, so you have to be still within the bounds of your mandate when you execute your search warrant, even though the search warrant is legally obtained. Article 130, searching domicile without witnesses. So ano, if you become law enforcer someday, ikaw mo magsagad-sagad ng search nga wala ka mo nagadalas ng witnesses. Diba? Dapat may members ng family nga present. Or kung wala members ng family nga present, dala ka mo sa barangay officials so that ang inyong search is lawful. Okay? Because if wala sang witnesses, then unlawful search na siya. And any evidence obtained sa unlawful search shall be inadmissible. So, kanagod lang sa effort. Okay? So, public officer or employee armed with a search warrant legally obtained searches the domicile papers or other belongings to any person, the owner, or any members of his family or to witnesses residing in the same locality are not present. So, dapat ang owner or di man kung walang owner, a member of his family nga may buot. Nakabutang, wala man nakabutang sa nga may buot. No? Pero ang member of a family nga may who's capable to understand what is happening. Okay, and two witnesses residing in the same locality. Oh, or pero just to be safe, biskan ara ang owner or a member of a family, dala na lang kamo sa duwa ka ng barangay official for proper nga pag execute sang warrant. It's also witness pa na sila nga nakita nga kung ano man ang na-search yung dira nga illegal materials. Okay? So, the mga previous nga articles are violations of the right against unreasonable searches and seizure, diba? Article 131, prohibition, interruption, and dissolution of peaceful meetings. So, this is if you commit this crime, you have violated the right of people to peaceably assemble, di ba? Elements, any public officer or employee nag-perform ka sang any of the following acts. First, prohibiting by interrupting without legal ground the holding of peaceful meeting or by dissolving the same. So, for example, na klase, kita may nagsulod lang yung police officer, nag-interrupt siya. Without legal ground, will he be liable under this article? Think about it. Okay? Hindering any person from joining any lawful association or attending any of its meetings. So, any person has the right to associate kung sino man gusto niya makaupod. Diba? So, kung ginapunggan ka, that is a crime under this article. And then, prohibiting, pero kung parents mo nagapugong sa imo, guys, wala naman na kay public officer or employee. Pero kung police mo papa, tapos ginapunggan ka, no, I'm just kidding. It's sang parents. They're just performing it as parents and not as public officer or employee. Okay? Prohibiting or hindering any person from addressing either alone or together with others any petition to the authorities for the correction of abuses or redress of grievances. So people have the right to assemble and to associate with one another. Amo na gani may mga unions nga ginatawag kung sa labor bala. There are unions, there are may mga nag-assemble to redress grievances. Diba? May mga nag-rally. If it's peaceful, then it should not be interrupted. Then again, syempre kung may mga ginamo na, kung may mga crimes na na-commit under that during that rally, then it's another story. But if it's a peaceful rally, then there's no harm on that. Sabad lang siya sa traffic, but then again, it's it's performing your political political function as a person. Nag-exercise ka lang sa iyong political rights, and that there's nothing wrong with it. Interruption of religious worship. So, bastos naman niya. If a public officer or employee, religious ceremonies or manifestations of any religious are about to take place or are going on and an offender prevents or disturbs, the same. So if it is with violence or threat, then it is qualified crime. So when you say qualified, do na gano siya, do aggravated. And Article 133, offending religious feelings. So acts complained of were performed in a place devoted to religious worship or during the celebration of any religious ceremony. And the acts must be notoriously offensive to the feelings of the faithful. So dapat may deliberate intent. So dapat ginahod-hungod mo giyang i-hurt ang feelings of the faithful. So this is a crime nga ginhimo siya crime because everyone has the right to express kumbaga sa ilang religious beliefs, and then you should not be disturbed, di ba? May isang freedom under your Bill of Rights for you to sa imong religious exercise ang imong faith. So yeah, no one should offend your exercise of religion. Okay, so that is, I think that's all under this title. Offending religious feelings is the last one in this title. So next week I will be uploading title 3. Medyo mahaba-haba ang title 3, guys. So I think I will chop it into 2 lecture videos so that it's easy man to upload if it's smaller. So if you have any questions, you drop your questions sa GC naton, and then answer some of the questions that I asked under this sa video lecture gani. Okay? So I hope you're all safe. Be safe, and I hope that you're all feeling feeling good in exercising sa inyong faith man during this Holy Week. Keep safe, and see you all sa aton nga meeting next week, next Saturday. Please do not forget the module exercises. Gamay lang siya, guys. Ipot ako module exercise, 5 questions for that much nga module. That's already so short. Okay, so bye-bye.